Good morning. We're here today with Sarah Holmes, who is candidate for District Court Judge in the 2nd Judicial District. Thank you for meeting with us, Ms. Holmes.
Thank you for having me.
Tell us a little bit about what your background is and what your qualifications are to be a District Court Judge.
Well, my background is that I am a native of Washington, born and raised in Beaufort County. I graduated from high school at Washington High School, went to NC State for undergraduate school. After that, I got married and moved away. Moved to my husband's home state in Arkansas, lived there for a while, started a family, and then I decided I wanted to be an attorney. I thought that I could help people and that I could make a difference by being an attorney. So I went to law school, started at University of Arkansas because that's where I lived, with a 3-year-old daughter that by that time I was raising by myself, sole custodian. So I worked 30 hours a week roughly to support the two of us, went to law school, and was sole custodian of my baby girl. When I finished law school, I was so homesick for North Carolina, for my family, for my friends, and for my home state that I just had to move back here. And that's what I did 25 years ago. Since then, I have been practicing law here in North Carolina. I have been in private practice. I've been an assistant district attorney. I've been a public defender. I've done lots of court-appointed work in the criminal courts, but I've also handled civil cases, family law, done some real estate. I've had a very diverse practice over the years. Currently, I'm working as magistrate judge in Hyde County.
What does a magistrate judge do?
Well, I hold small claims court, which means that civil matters of $5,000 or less, civil disputes between people. I do summary ejectment cases.
What in the world is that?
Well, that's if you have somebody in your house that you need to get out. We most often see that in landlord-tenant cases. That's where somebody has a rental property and for various reasons a tenant doesn't leave the property that the landlord wishes for the tenant to remove himself and his property from, and when they can't resolve it themselves, they file a small claims action, and it's called a summary ejectment.
Okay. I understand you also deal with probable cause hearings.
I do.
Explain to those who may not be familiar with that process what probable cause is.
Well, when an officer wishes to issue a warrant for arrest, they come to the magistrate and they explain to the magistrate under oath what their evidence is. And the magistrate then hears what the evidence presented is and makes a decision about whether or not there is sufficient cause to issue that warrant. There are also cases where people have disputes where an officer is not available or is not there when these matters occurred. You see this frequently with domestic violence cases where a husband and wife or a boyfriend and girlfriend who are living together as such get into a dispute into disputes or into a dispute, and perhaps one has assaulted the other, and they would come in as a citizen complaint and fill out a form requesting assistance from the courts for the person who assaulted the victim to be charged with that criminal assault.
Okay.
And I would hear that matter, and I would determine whether or not there's sufficient evidence to determine if the assault really took place. And if it did, in those cases, I would issue a warrant for arrest. And in those cases, we also put a 48-hour hold on the assaulter so that the victim has an opportunity to either remove himself or herself from the premises, or to go to the district court judges and get a domestic violence protective order in order to keep the assaulter away. It's a safety measure.
Very good. If elected to be a district court judge, it's my understanding that domestic court is a big part of most district court judges' responsibility. Explain a little bit about what that process is.
Well, domestic court or family law, it's known by both. People use those names interchangeably, or when couples have issues that they cannot resolve themselves. Perhaps they are going through a divorce, or they have property that they needed to have divided up. We would have an equitable distribution in that case. We would hear matters of support. If you have one half of the couple that's worked and one half of the couple that's taken care of the home, then you might have a support in a sufficiently long life of a marriage that you would order one party to support the other for a specific length of time. You may or may not have children that you need to decide where the children are going to live, what's the best placement for those children, and of course placement of children, custody issues always depends on what's in the best interest of the child and or children.
So custody would include visitation issues of the
correct.
Non-custodial parent.
That's right.
Then.
Because you don't want children to not be able to see their parents. It's always better, in my belief, that children have interaction with both of their parents as much as they possibly can, and the reason for that is because it's good for the children. Children thrive better. Children are more well balanced if they have interaction with their parents.
We need to find a way to take a subtle shot at Daryl Caton, and the issue of treating people with respect is what I would propose I ask you about. And then you prepared to answer that?
You can also ask me about if I'm taking money from lawyers.
Great.
Those are both.
Right.
And I don't even have to say his name. I can just say this is what I'm doing.
Great. Great. Ms. Holmes, we have been covering district court in Beaufort County, not in the other counties, but here for quite some time. And very candidly, we have a number of people who appear in our local district court who contact us and are very displeased with the way they were treated in district court. I'd rather us not go into specific details, but we believe that is an issue how would you deal with it?
I would deal with this the way I deal with people in small claims court currently, and that is, just because you're going to rule against somebody, you don't have to demean them, you don't have to belittle them, you don't have to intimidate them. I believe because my family is born and raised Southerners, that we treat people with respect. And even when you're ruling against people, you don't have to talk down to them. You don't have to be cruel or disrespectful. I can certainly say to someone, I can't rule in your favor because this is what the law says about this. But that doesn't mean that I don't appreciate that you're here in an environment that is not necessarily what you're accustomed to and not necessarily where you want to be. And just because someone is in the court system doesn't mean they can't be treated with courtesy and respect.
Very good. One of the other complaints that we receive about the local court system is the inference that it is controlled by a small group of people. An example of that is that it's very rare to have a contested race for district court or superior court, and in fact in this election there are a couple of seats that are not contested. The fact that you're contesting this seat is a relatively rare event in our perception of court in Beaufort County. Why do you think that's true? Why don't we have people who step up and run for being judge any more than we have in the past? And what caused you to decide you were going to buck the system, as it were?
Well, part of the issue is that if you are a practicing attorney and you have cases that are being heard in front of a sitting judge, you run the risk of your entire practice really being influenced by a judge that's hearing cases that perhaps could be retaliating against you. And nobody wants to take the chance that their clients, whether they're plaintiffs or defendants, could be impacted by a dispute caused by a contested race.
So you have to be an attorney to run for a district or superior court judge.
That's correct.
In North Carolina.
You have to be a practicing attorney.
It's my understanding it has not always been that way, that in the past you could file to run to be a judge just like you could file to run to be the sheriff or the county commissioner.
In my lifetime you had to be a practicing attorney.
Okay.
Now, not all magistrates are practicing attorneys. There are some that are not, and part of the reason why we have the difference for magistrates versus district court judges is because some of our smaller, more remote rural counties just didn't have enough practicing attorneys as residents in order to fill our magistrate positions. So there's an exception for magistrates that does not exist for district court judges.
Well, let's go back to this business of attorneys who practice before a judge or have some relationship with a candidate to be a judge, such as making campaign contributions and that type of thing. My perception is that most people just think that's wrong. They just do not think that attorneys who appear before a judge ought to be giving the judge money, even if it is for a political campaign. How do you feel about that?
Well, I can't speak to how most people feel about it, I can only speak to how I personally feel about it, and what I have read about it and how I feel is that a judge who asks an attorney who's going to appear in that judge's courtroom, a judge who asks that attorney for money is a form of legalized extortion. Because if you have a case that's being brought in front of a judge and that judge says, I need a campaign donation from you, if you say no, then what happens to your client? And if you say yes, is your client getting a benefit that perhaps they're not entitled to? And how do you know whether the decision is not influenced by either the amount of money given, that any money is given, or that money was denied to be given? And it's human nature to look more favorably on someone who is actually supporting you. So early on, when I decided to run, I told my campaign volunteers, if attorneys come to you and say they want to give my campaign money, we need to say no, because I don't want that appearance of impropriety.
So you're not accepting campaign donations from attorneys that might practice before you?
I'm not, and I have refused campaign donations thus far, and I will continue to do so.
Wow. What else would you like to have the readers know as a closing statement?
I am a conservative Republican in this district. I am the first conservative Republican to run for district court judge in this district in decades. And I am running because I think it's time to bring conservative values to our judiciary. I think it means fairness and equity, and I think it means civility.
So I interpret from that, I just want to check and see if I'm reading it correctly, that you feel there's a need to change the court system, and that one way to do that is to vote for conservative judges who will treat everyone fairly. Is that an accurate perception of your position?
I just feel like it's important for people to be treated fairly and equitably, and I think that conservative values substantiate that kind of treatment for everybody.
Very good. Thank you very much. We appreciate your time.
Thank you. Thank you for having me.